Welcome to the Docketing Excellence Webinar Series.
Welcome to the Docketing Excellence Webinar Series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman, Lundberg, and Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence Webinar Series is free. To listen to our past webinars or to register for future webinars, go to the Docketing Excellence Series tab on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today is, I think, the 20th now in our series. Today's topic is Understanding the Unified Patent Court, UPC, and the Unitary Patent, UP, under the European system. We've allowed time for questions at the end of the webinar. Questions may be submitted using the question button on the right-hand side of your browser window. You can submit a question at any time during the presentation, but the question will be held in a queue until the end of the presentation. Before I begin, though, I want to let people know that Black Hills IP is presenting a free full-day IP docketing seminar in Washington, D.C. on November 8th. The content of the seminar is different than the content of the webinars we've presented so far. So if you've listened to our full webinar series, the seminar will not be a repeat. It's an interactive workshop with something to offer even for experienced docketers. To register for the seminar in D.C., go to the Docketing Excellence Series tab on the Black Hills IP website. The presenters today are myself and Bryn Williams, who is an attorney with the Schwegman, Lundberg, Wissner firm in their UK office. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center, which is now University of New Hampshire, for 5 years. Bryn, can you introduce yourself?
Hello, everybody. I'm Bryn Williams. I'm a UK principal for Schwegman, Lundberg, Wissner in the UK, and I'm based in the Glasgow office. I've been a patent attorney for 15 years with extensive experience before the European Patent Office. I'm also joined by my colleague, Catriona Good, who has been doing a lot of work on the UPC stuff and is here to keep me right and make sure I don't mislead any of you.
Well, great. Thank you both, and Bryn in particular, thank you for taking the time to walk through this topic with everybody. I'm going to turn it over to you to get started.
Okay, thank you very much. Before we start, I want to just talk a bit about terminology. Just on the terms Europe, the European Union, and the European Patent Convention. I'll start with Europe. That's the easy one. Europe is the continent which we live on over here, and it consists of 44 countries. 28 of these countries have formed a trading and political bloc called the European Union. This allows for free movement of goods and people between member states. Over the years, there has been a movement towards political union with the harmonizing of laws to create common legislation across the member states. One such harmonization, which I'm sure many of you will know of and has been a great success, is the harmonization of trademark law and the creation of the community trademark, which is a single trademark covering all 28 member states. When the British refer to Brexit, this is the process by which the UK are planning to leave the European Union in about 18 months' time. Alongside the European Union as a European entity is the European Patent Convention, which has been signed by 38 countries, including all 28 of the European Union countries. This convention allows for the centralized granting of patents across the convention states. As this seminar deals primarily with the unitary patent, I'm just going to give you a flavour of what is presently in place under the European Patent Convention. This convention allows for central prosecution as far as grant, however, does not provide for a single European patent. To have an enforceable patent from a European patent, the patentee has to validate the granted European patent before the chosen national offices. So, therefore, if your patent grants, European patent grants, and you want to have rights in Spain, you have to comply with some formal requirements at the Spanish Patent Office, and they are obliged to grant you a Spanish patent. If there's any legal action to be taken with regard to infringement of this Spanish patent, it will be done at the national level in the Spanish courts, and decisions are only binding on Spain. So, let's turn into the matter at hand. There has long been a desire for a single European Union-wide patent and a European Union-wide court to rule on infringement and validity of these patents. One patent covering the whole of the European Union and one court which makes binding decisions across the whole of the Union. The Unified Patent Court is the realization of this desire. A single court with a central jurisdiction with the intention of unifying national patent laws across all participating countries. The unitary patent is a new validation for European patents, which allows multiple countries to be covered in a single validation. The desire for a unified court and a unitary patent across the whole of the European Union has not been fully realized, however. Some countries are not participating. On this graphic, the green and red countries are the European Union states. The grey countries are those in the European Patent Convention, which are out with the European Union. Of the European Union countries, 3 states are not playing ball. Spain, Poland, and Croatia have all decided not to participate. They are shown in red on the graphic. These countries have a number of reasons for not participating, but the common one is the granted unitary patent will not be translated into their national languages, which they feel is important for economic growth. A unitary patent can only cover the European Union states who participate. The green countries are all participating states or intend to participate states. The Unified Patent Court and the Unitary Patent are expected to enter into force during 2018. They will come into force when the UK and German parliaments, as 2 of the biggest filers of European patents, have passed the legislation into effect. Implementation is still some months away, as in Germany, a reference has been made to the German Federal Constitutional Court concerning the validity of the legislation passed by the German Parliament to implement the Unified Patent Court and the Unitary Patent. At this stage, all we can say is the new system should come into effect in 2018. Once the German and British Parliaments have passed the legislation, the systems will come into place on the first day of the 4th month after legislation was passed. To approximate that, this period will last about 3 months and is called the sunrise period. For all patents granted after the end of the sunrise period, a unitary patent can be selected instead of 1 or more national validations for participating countries on that day. I repeat, on that day, because it is an important docketing point. The European patent only covers countries which have passed the requisite legislation before the date of grant of the patent. On the earlier slide, there were 11 states who were intending to pass legislation but haven't done it yet. If they do not pass legislation before the end of the sunrise period, then they cannot be included in the first unitary patent validations. So there is a possibility that a unitary patent from one granted patent could be effective in different states than another unitary patent granted a few weeks later from a different granted patent. There are some other useful docketing notes that can be made. Some clients will particularly want a unitary patent, and in the run-up to the system coming into effect, their case may go to grant, making them ineligible, like during the sunrise period, for example. So there is a possibility to delay grant. This can be done in 2 ways. One is that if a renewal fee is due to be paid on the European patent, then don't pay it. A European patent will not grant if there's an outstanding renewal fee. An alternative but slightly higher risk strategy, if this is not possible, is not to reply to the invitation to grant communication from the EPO. This would send the case into further processing and could be used to delay grant for 4 to 6 months to get inside the unitary patent window. This does not come without its risks, however, as the case may be re-examined. The second point I make is that the deadline for requesting a unitary patent validation is shorter than requesting a national validation. National validations have to be filed no later than 3 months after the publication of mention of grant in the European Patent Bulletin of the patent, whereas for the unitary patent validation, it's only 1 month. Therefore, there are 2 dates to docket, the unitary patent validation date and the national validation date, one being 2 months before the other. Another point to consider are the translation requirements. An existing European patent requires translation of the claims into English, French, and German. National validations then make their own rules, some countries requiring full translations, some countries requiring only claims translations, and some requiring no translations at all. Going forward, English language unitary patents must be translated in their entirety into either French or German. If your client is going to go for a unitary patent validation, it will probably be cheaper to request this translation when you request the claims translations at the intention to grant stage. This would also be good practice because it will ensure you comply with the 1 month validation deadline much more easily as you have the translation done prior to grant. Further docketing notes include we would recommend considering a new matter code or new file code for UP cases. Presently, we would have a number stem, followed by EP for European patent, to which we would add the national validations thereafter. So NO for Norway, FR for France, etc. We're now going to implement a system where we have UP for unitary patent validations. The unitary patent also offers potential time savings and cost savings for your clients. Fewer validations, fewer translations, and a single renewal fee post-grant can give significant savings to the client if they would normally validate in 3 or 4 of the unitary patent states. These cost savings, however, must be weighed up against the unitary nature and interpretation of the patent, which I'll now move on to. These aspects come into consideration under the Unified Patent Court. There is a lot of discussion about how this court will work, and many attorneys are advising that the opt-out provisions provided for are not used or are exercised until the court settles down and we see the quality of decisions we are getting from the court. If we opt out of its jurisdiction, then we use the conventional systems of national court where law is well established to decide infringement and validity matters. With this in mind, it should be noted that the Unified Court will be the sole jurisdiction for unitary patents. This cannot be avoided. If you select a unitary patent validation, then you cannot prosecute through national courts. Eventually, for the countries participating in the UPC will have sole jurisdiction for all patents granted. That is European patents, unitary patents and national validations. The situation can only be avoided by filing nationally direct filings and bypassing the European patent system entirely. There are pros and cons of the European system being implemented under the Unified Patent Court. It's not just the quality of decisions that have to be considered when deciding whether or not to accept the jurisdiction of the Unified Patent Court. Under the UPC, EP-validated national patents will be interpreted as meaning the same across Europe, and decisions made by the UPC will be binding and have effect in all EU countries, i.e. a decision regarding an EP patent validated in France will also be binding on an EP patent validated in Germany. Therefore, the UPC could be a useful litigation tool to obtain an injunction across all countries covered by the EP patent, rather than having to apply the national injunctions as is the present case. The counter to that is, together we stand, united we fall. This means your European patent could be vulnerable to central attack, where all countries covered are wiped out in the proceedings brought before the UPC. So I've mentioned opt-out a few times. How does this opt-out work? During the sunrise period, any existing European patent can be opted out of the UPC, and a successful opt-out is guaranteed. This opt-out lasts for the lifetime of the patent. During the next period, known as the transition period, a patentee can choose to opt out of the UPC. However, this can only be done if litigation has not started. I can see a large number of invalidity cases being filed on the first day to catch people who have not opted out during the sunrise period. If this happens and the claimants are successful, these European patents will fall in their entirety in all national validations in the participating states. This transition period will last a minimum of 7 years and up to a maximum of 14. During this period, an opted out patent can opt back in again up to 1 month before the end of the transition period. If this deadline is missed, then the patent will remain opted out for its entire life. There are 2 docketing points to be made. The first is that you must have a record of all your opted out and opted in cases, and that includes cases which you've prosecuted yourself and, crucially, cases which you've transferred in from another attorney firm. You must know what jurisdiction these cases are working in and where they are in the process. And secondly, you must docket the deadline for opting back in again, which is 1 month before the end of the transition period, which presently we don't know when that's going to be, but I'm sure they'll tell us in good time. The final point to note is that if you've opted out and choose to opt back in again, you cannot subsequently opt out a second time. On average, patent holders validate in 3 to 4 national territories. Unless you regularly validate your EP patents in more than 3 countries, the costs involved in litigating a unitary patent may be prohibitively expensive for it to be of interest to most patent holders at this time. The most pertinent question for patent holders is whether to be under the jurisdiction of the UPC or not. The largest concern is the unitary nature of the UPC and the risk of central attack, revoking or invalidating your patent across Europe in a single action. The following slides show a comparison of the pros and cons of both national EP and UPC forums for the main actions brought in relation to a European patent. It shows the perspective from both the patent holder and the patent challenger. The first one concerns invalidity and revocation actions. The current status of the national proceedings, where cases are decided nationally in each country, for a patent holder, it's a good thing. An attack on one country affects only that country. For a patent challenger, it's complex and expensive to challenge in each country covered by European patent. The converse is true under the UPC, which is decided centrally. For the patent holder, there's the risk of central attack and invalidation across the whole of Europe. For the challenger, a successful invalidation in one European state will invalidate it in all countries covered by the EP patent participating in the scheme. The other side of the coin is infringement and injunctions. For national proceedings, for the patent holder, it's expensive to defend actions if multiple actions are raised across several countries. And a plus and a minus is the discrepancy of decisions. For the patent challenger, again, it's expensive and they suffer from the same discrepancy of decisions. Under the UPC system, for the patent holders, single, interim and full injunctions are possible across all UPC countries covered by the European patent, which they would see as a negative, which for the patent challenger is a positive. There'll be much more talked about these opt-in, opt-out options over the coming months as the system becomes clear how it's going to work. So, to finish off, I'll give you an example of the various options available, and this will hopefully be clear, but it will also show you how complex it is. Let's take an example of protecting 4 states, Italy, Ireland, the UK and Norway, in a number of different stages over the 4 years, a few years ahead. The first thing to note is that Italy, Ireland and the UK will be part of the unitary patent and the unified patent court system, whereas Norway is outside. Prior to ratification, the only option for validation is national validations in each individual country. Jurisdiction will be before the national courts. Once the unitary patent court is established after the sunrise period, unless the Italian, Irish and UK patents have been opted out of it, they will fall within the jurisdiction of the UPC. For Norway, as it's not a member of the European Union, it will always be outside the jurisdiction of the UPC and will be governed by the Norwegian courts. The next example is during the sunrise period. Again, national validations are only available because the unitary patent hasn't come in yet. And jurisdiction will be before the national courts. Again, once the UPC comes in, then jurisdiction will switch to them unless the patentee has opted out. During the sunrise period, this opt-out is guaranteed. During the transition period, the unitary patent has come in. And there are two options for validation. National validations again across all states, or a unitary patent validation, which will cover Ireland, Italy and the UK, as well as all the other participating states. A national validation will still be required for Norway. For option 1, the jurisdiction will be the Unified Patent Court for Italy, Ireland and the UK, unless the opt-out is exercised, and this opt-out can only be exercised if litigation has not started in those countries. For option 2, the unitary patent and the Norwegian validation, the Unified Patent Court will have jurisdiction over the unitary patent regardless of whether you want it to have or not. The Norwegian national validation will fall within the jurisdiction of the Norwegian courts. The final example is after the full implementation of the UPC, once the transition period is finished. Again, there are two options for validation: national validations across all states, or a unitary patent validation which will cover Ireland, Italy and the UK as well as the other participating states, and the national validation for Norway. The jurisdiction will be the UPC for those countries within the European Union, and the Norwegian courts will decide matters for the Norwegian validation. And that's me finished on my main presentation, so back over to you.
Great. Thank you, Bryn, for that explanation and those examples. Those are particularly helpful. Today we've talked about the significant changes to the process of obtaining and enforcing patent rights in Europe. The Unified Patent Court and the Unitary Patent and the European system are expected to become effective in 2018. There are a number of strategic considerations that Bryn talked about that the attorneys in our audience will need to explain to their clients. In addition, there are procedural changes that will need to be docketed correctly. If you're a docketer listening to this program, there are at least 4 important things I think you should take away from this. First, the validation deadline is shorter for the unitary patent than for the current national validation process. As Bryn explained, the validation deadline for a unitary patent is 1 month from the publication of the mention of the grant. In contrast, the deadline for national validations is 3 months and will remain 3 months. You should docket both of these validation deadlines. And just a side note, depending on the docketing system that you work in, different docketing system vendors are on different schedules for updating country law in their systems. So when this change does become effective, you need to see if this is has been updated in the country law in your docketing system, and if it hasn't, you'll need to come up with a way to track that yourself in your system. Second, if you don't already docket a deadline for providing validation instructions to your foreign agent, it's a good practice to do so. And in this case, you should docket a deadline for providing validation instructions, and I recommend that you docket this with the other actions associated with the intention to grant stage, so that you have the validation instructions ready when the patent grants, because you have that short turnaround time on the unitary validation. If you do select the unitary patent, you should validate as early as possible, particularly as this process is just coming into effect. You should validate as early as possible, so if something goes wrong, there's some kind of defect in your validation process, you can always fall back on that national validation because that's at a later date. But you have to have that defect come up within the 2 months if you wait until the 1 month deadline to validate your unitary patent. So I'd say it's best practice to request validation for the unitary patent early, even before the 1 month deadline. And to do that, you should be getting those validation instructions during the intention to grant phase, and I'd recommend docketing a instructions deadline. Third, in order to docket the validation deadline for the unitary patent, Bryn mentioned you should have a new code in your docketing system or an extension in your docketing system so you can identify the matter or the record in your system that is associated with the unitary patent. You probably use the extension EP for the European patent application and the individual country codes for national validations like GB, FR, IT. And Bryn suggested considering the extension UP and adding that to your internal reference number to identify the matter that's associated with the unitary patent. Fourth, remember that the European patent only covers countries which have signed up for the unitary patent system at the time the particular patent grants. You'll need a method to track which countries are covered by the unitary patent in your docketing system. And you can think of this similar to the PCT process. Those of us that have been practicing for a while will remember the day when we had to select the PCT countries when we filed the PCT request that we were interested in, and probably had to have a way to track those. So you may already have a process for doing that, but just remember that the countries that are covered by your unitary patent will be a function of what countries were signed up for this at the time your patent granted, and you need a way to track that, a method for tracking that. There's some additional docketing considerations for opting out and opting back into the jurisdiction of the UPC that get fairly complicated, but those are also things to think about. So as docketers and paralegals, I think those are some of the key takeaways that I want to make sure you come away from this program with. If you have questions about today's program, you can submit those through the question button on the, I think on the right side of your screen. We have a few questions in the queue. If you have questions regarding Black Hills IP services and processes, we have Jim Brophy's contact information, our Vice President of Sales. Please reach out to him. So let's see what we have for questions. Bryn, I'm going to read these to you, starting at the top. The first one is a good question. The question is, the decision whether to go national validation or unitary patent validation is relevant only once the decision to grant is received, ? There is no reason to make this decision earlier, correct? Can you answer that?
Yes, in principle, there's no reason to make the decision earlier. The deadline's short. It's only a month. Once the decision to grant is, or once the mention of grant is published, which is a date informed in the decision to grant, and there are some things to do. There's a bit of translating to be done. So yes, you can leave it. We would recommend doing it a bit earlier because you are talking about English, French, and German translations, which is a process you have to go through to get to the decision to grant when you do the claim. So there's probably savings to be done there. But yes, in principle, you can leave it till then.
Okay. Next question, and this could be probably the topic of a webinar itself, but Bryn, how will Brexit affect this system?
Our national obsession at the minute, Brexit. If you don't know what Brexit is, anybody out there, then just go and find a British tourist and talk to them about it, and you'll be there for days. How will Brexit affect the system? Fortunately for patents, it's different with trademarks, fortunately for patents, the European Patent Convention covers more than the European Union. So we envisage a situation where the unitary patent will just shed a British patent if Brexit happens. On the counter side to that, one of the things that you've seen consistently coming up through that example is Norway is not part of the system, so therefore it's never going to be governed by the Unitary Patent Court, the Unified Patent Court, sorry. With Britain coming out as well, there is moves to try and increase the the scope of the Unified Patent Court to cover all European Patent Convention countries. However, that's speculation at the minute. So Brexit shouldn't affect it to any great extent. What will most likely happen is a UK patent validation will be carved off all unitary patents.
Okay. All right, I have 2 or 3 questions asking about the availability of the slides and the PowerPoint and whether the docketing tips that I just read will be available. So after the webinar is completed, we always post the slides along with the audio recording on our website of all of our previous webinars. It'll take probably a day for us to get these posted, but the slides and the audio recording, which will include the docketing tips that I summarized, will all be available. You can go to the blackhillsip.com website and then go to the Docketing Excellence materials. There will be a section there for previous webinars, and give us 24 hours or so to get this posted, but this will all be available on our website. The next question, Bryn, will there be a listing of countries as they become ratified? Will the EP website have that listing? So how can people keep track of the countries?
Okay, what we will do, there are a number of websites. I'll amend the slides to include a link to one of them on the graphic page of the countries. One thing, unified-patent-court.org would be one of them, but we'll put a link on the slides before we post them.
That's a great idea. Thanks, Bryn, for doing that. So that link will be on the copy of the slides that we post. We have 2 questions about annuities and renewals. What is the difference in the renewals process for the unitary patent, and how will annuities be handled?
Okay, from that perspective, the differences are that there will be one renewal fee payable to all the participating states, to cover all the participating states. It will be payable to the European Patent Office, I'd imagine, so it will be no different really to paying the pre-grant renewal fees on European patents. Annuities be handled, okay. The unitary patent renewal fees will be equal to the combined renewal fees of the top 4 countries where traditional European patent is granted. These would be, at the minute, Germany, the UK, France, and the Netherlands. The only financial disadvantage of a unitary patent remains that it cannot be pruned. Currently, you can drop your national validation just to become of less interest to you. A unitary patent, you'll have to pay these renewal fees for the full 20 years, and it's all or nothing. You'd have to get rid of the unitary patent if you wanted to get rid of one territory. They currently estimate that the fees over 20 years would be of the order of €35,000 for those 4 countries, or the equivalent amount.
Okay. The next question is, how does this affect, if at all, divisional application filings?
Okay, I'm just having a quick look through my notes here. A divisional, just a note here.
And while you're,
yeah,
oh, go ahead.
Okay, so,
well, I was going to say, while you're looking at your notes on that, I was just going to let everybody know that Bryn and his colleague Karen did a webinar a few months ago for us on the EP national validation process, not the unitary patent, but just the basic national validation process. That was a very, very informative webinar and has a really great set of slides. Those slides and the audio recording are also available on our website, and you can watch that online if you want more information about the national validation process. That doesn't answer the divisional question, though, so I'll turn that back to you, Bryn.
She was much better at handling questions than I was. The notes I've got here is a patentee could consider having a parent patent with a unitary effect with a very narrow scope and an opted-out divisional with a wider scope. This double shoot strategy may be costly, but it allows a patentee to hedge his bets and therefore may be suitable for key products. In this context, it should be noted that the restrictions on filing divisionals at the European Patent Office no longer apply. This will enable a patentee to obtain a unitary patent and a traditional European patent for almost the same technology. So there's a bit of strategy work to be done there.
Yeah, and I do think there is a lot of strategy work for the attorneys listening in terms of counseling their clients and advising them which way to go. And for the initial period, I think that will be one of the harder things here to do, is to determine which way to go. Don't you agree?
Yes, absolutely.
Last question, and I want to be careful on terminology. The question says, can you search unified patents in the European Patent Register? But the unified term, and I made this same, I mixed these words up too myself until I got a little more familiar with it. The term unified goes with the patent court. It's the unified patent court. The term unitary goes with the patent. It's the unitary patent. So I assume that this person is actually asking, can you search the unitary patents in the European Patent Register? Do you know if that will be, people will be able to do that, Bryn?
Yeah, currently on the European Patent Register, you can see where it's been validated, and they'll just add a line for unitary, I'd imagine. So once it comes in, there will be a solution for it, because you've got to provide comfort for people that they're not infringing patents, so they've got to be able to find them. So I'm sure something like that will be in place, yes.
Okay, good. All right, that is all that we have in the queue for the questions. Again, these slides will be posted. Give us about a day so Bryn can add the link to the slides, and then we can get the material online. Before I go, I want to announce 2 new webinar series that we are kicking off next week. One is called our Foreign Excellence series, and the other is called our Operations Excellence series. I'll be coordinating both of these. And actually, you know, I said foreign, but we're using the term international, the International Patenting Excellence series. This series is really, I think, going to be the most useful to attorneys. It's going to be the types of information that you would use if your client said, should I patent in China, or should I patent in Brazil, or whatever country. We'll be going over high-level country information about the markets, the economics in those countries. We'll also talk about the who's filing in those countries. I think it's useful to see what types of what companies are your clients' competitors filing in particular countries. We'll also talk about the scope of patent protection that's available in the individual country, and then to the extent we can comment on the ability to enforce in those countries. So that's a high level of what we'll cover. We have about 20 different countries that we plan to cover. They're the big ones that your clients probably file in: China, Japan, Korea, Taiwan, Malaysia, Singapore, UK, Russia, Canada, Mexico. There's more on the list, but those are some of the ones on the list. And each webinar will focus on a single country. The first webinar is next week, October 26th, and it will focus on China. The next series that we are also launching next week is an Operations Excellence series. This is probably more useful, although not necessarily limited to paralegals. We will be focusing on best practices for things like managing the invention disclosure process, drafting and filing U.S. applications, responding to non-final office actions. These will be the procedural aspects of these different types of things that we do with the U.S. Patent Office. So the Operations Excellence series will be focused on activity with the U.S. Patent Office and goes beyond the docketing, which we've talked a lot about in our previous webinars, and focuses on some of the other paralegal and administrative aspects of the different events and documents that we file with the USPTO. Each of these series will be presented once a month, starting next week, and we'll have the login information or the registration information posted on our website later this week. So stay tuned and check back if you are interested in registering for either one of those. And then finally, for the Docketing Excellence series, I'm working on defining the next set of programs for this series, and those will start up again in January 2018. So again, watch our website for details for additional docketing webinars starting in January. To register for any of these, go to the Black Hills IP website. And thank you very much for participating today. We hope you join us for this and other webinars in our various series. And also, if you're interested in docketing, please consider joining the LinkedIn Docketing Excellence group as well. Thank you very much.